You are on HOA outplayed. I stayed calm and let her talk. You cannot pile snow within 6 feet of the curb. Teresa Stewart is standing in my driveway at 7 in the morning holding a clipboard and a bucket of gravel, voice loud enough to wake the neighbors. Behind her, a tow truck idles at the end of the block, exhaust cloud glowing under the streetlight. She taps the clipboard twice and says the association is issuing an immediate violation notice plus a $200 fine, effective now, and if I do not move the snow pile within 1 hour, she will authorize a tow on any vehicle obstructing compliance work. I am in Fargo, North Dakota, and this is the Timberline Whiteout Ridge Association, where the committee micromanages shoveling like it is architecture. I work as a building maintenance technician, which means I know every rule and every loophole, and right now I am standing in my green parka and red knit beanie with a hand warmer packet in my palm, wondering how a woman with a bucket of gravel thinks she can rewrite the covenant midwinter. I look at the snow pile. It is 3 feet from the curb, not 6, and I cleared my driveway last night after the second plow pass dumped a wall of compacted slush across the apron. Teresa is the landscaping committee lead and she complains daily about something, but this is the first time she has shown up with a tow threat before breakfast. I ask her where in the covenants it says 6 feet. She does not look at the clipboard. She says the rules do not care about your excuses and neither do I. Then she sets the bucket down and takes a photo of the snow pile with her phone. I can see her breath in the cold air. I tell her I measured the setback last night and it is legal. She says the curb rule was updated in the winter addendum and I should have read it when I moved in. I ask when the addendum was published. She says it does not matter because enforcement is immediate and the fine is already logged. I am on probation at a new job and I cannot miss work for HOA hearings, which means I need this resolved fast before it spirals into a lien or a meeting summons. I tell Teresa I will move the pile today, but I want a written copy of the addendum she is citing. She says it is posted on the resident portal, and if I do not have access, that is my problem. Then she picks up the bucket and dumps a handful of gravel onto the driveway apron right where the slush meets the concrete. She says this is evidence of improper drainage that is damaging the shared infrastructure, and she is documenting it for the next compliance review. I watch the gravel scatter across the ice. My neighbor 2 doors down is shoveling his walk and he pauses mid-scoop to stare. Teresa turns and waves at him like she is doing a public service. She walks back to her car and drives off. The tow truck stays for another 5 minutes, then leaves. I call my next-door neighbor, a calm guy named Marcus, who has lived here for 6 years and is tired of Teresa and the committee turning every storm into a compliance trap. He comes over 20 minutes later with his own shovel and a printed copy of the original covenants. We sit in my kitchen and flip to the section on snow removal. The rule says snow cannot block the street or the sidewalk. There is no curb setback distance. Marcus points to the signature page and says the winter addendum Teresa mentioned does not exist in the official docs, and if she is enforcing a phantom rule, that is grounds for a dispute. I ask if he has seen her do this before. He says yes. Last year she fined 3 households for ice dams on the roof and claimed the association had emergency authority. Then the management company refunded 2 of them after a lawyer got involved. He says Teresa has been escalating every season because no one pushes back. I check the resident portal on my phone. The login works, but the documents section is empty except for the original covenants and a newsletter from October. No winter addendum. I screenshot the page and save it to a folder. Marcus says I should file a written dispute with the management company before Teresa logs another fine. I draft an email on my laptop, attach the covenant screenshot and a photo of the snow pile showing the 3-foot setback, and send it to the compliance email address listed on the portal. The auto-reply says disputes are reviewed within 5 business days. I forward a copy to my personal email and print a hard copy for my records. Marcus says the problem is Teresa does not wait for review. She stacks fines daily until the balance is big enough to threaten a lien, and by the time you prove she is wrong, the management company has already logged the fees. He says his advice is to keep a paper trail for everything and do not give her a reason to escalate. The next morning I get a second violation notice taped to my front door. It says the snow pile was not relocated within the 1-hour compliance window, and the association is adding a $50 late fee plus a $75 inspection charge. I check my driveway. The pile is gone. I moved it to the side yard last night, exactly where Marcus suggested. I take a photo of the empty curb area and the side yard pile. Then I pull the notice off the door and read it again. The timestamp says the inspection happened at 6:45, which is 15 minutes before I left for work. I review my doorbell camera footage. At 6:30, Teresa walks up my driveway with the same clipboard, stops at the curb, takes a photo, then tapes the notice to the door and leaves. The snow pile is already gone in the frame. She documented a violation that did not exist. I save the doorbell clip and send it to Marcus. He replies in 10 minutes and says this is fraud and I need to escalate immediately. I call the management company and get a receptionist who says the compliance officer is out until next week. I ask to speak to anyone else. She transfers me to a voicemail. I leave a message explaining the false inspection and the missing addendum, and I say I am requesting a formal review and a refund of all fines. I also ask for a written response within 48 hours. I do not hear back. 2 days later, I get a third notice, this time by certified mail. It says my account is in arrears for $325, and the association is placing a hold on my portal access pending payment. I call the management company again. This time, the compliance officer answers. Her name is Brenda, and she sounds tired. I explain the situation from the beginning. She says she does not see a dispute on file. I tell her I sent it 5 days ago. She puts me on hold. 3 minutes later, she comes back and says the email system had a glitch and my message was not logged. She says I need to resubmit. I ask if she can see the violation notices in the system. She says yes, 3 violations for snow setback and drainage damage. I tell her the setback rule does not exist and the drainage claim is fabricated. I hear typing. She says the notes indicate Teresa documented the violations with photos and gravel evidence. I ask if she reviewed the actual covenant language. She says that is not her role, she only logs what the committee reports. I tell her I have doorbell footage proving the second notice was issued after I corrected the first violation. She says I can submit that with my dispute resubmission and it will be reviewed when the officer is available. I ask when that is. She says 7 to 10 business days. I tell her I cannot wait that long because Teresa is stacking fees daily and my job does not allow time off for hearings. She says the best she can do is flag the account as disputed, which will pause collection, but not stop new notices. I agree and hang up. That night I print every document I have, the original covenants, the portal screenshots, the doorbell footage stills, the 3 notices, and the email chain. I put them in a binder with tabs. Marcus comes over and we go through it together. He says the gravel bucket is the signature detail. Teresa has used it in every dispute he has seen. She dumps gravel and claims the homeowner caused erosion or drainage issues. Then the committee uses it to justify infrastructure fees. He says the association refunded one neighbor last year, but only after a lawyer sent a demand letter. I ask if he still has the lawyer's contact. He says no, but he knows the neighbor, a retired engineer named Paul who lives 3 blocks over. Marcus texts him, and Paul replies immediately. He says he will stop by tomorrow with his paperwork. Paul shows up the next afternoon with a thick folder. He is calm and methodical, and he walks me through his case. Last winter, Teresa hit him with 4 notices for roof ice and drainage. The total fine was $600. He disputed it, and the management company lost his packet twice, then claimed it was incomplete. He hired a lawyer who sent a certified demand letter citing the covenant language and threatening a lawsuit for harassment. The association refunded the fines within 2 weeks and issued a formal apology. Paul hands me a copy of the demand letter. It is 2 pages, and it is very specific about the covenant sections, the false documentation, and the legal definition of harassment under the North Dakota Homeowner Protection Statute. He says I should adapt it and send my own version, but I need to include proof that Teresa is misrepresenting the rules. I show him the doorbell footage. He says that is gold, and I should also get a written statement from Marcus as a witness. Marcus agrees on the spot. I spend the weekend drafting the demand letter. I cite the covenant sections Paul identified, attach the doorbell footage stills and the portal screenshots, and include Marcus's witness statement. I also add a section demanding a written copy of the winter addendum Teresa is enforcing, with a deadline of 5 business days for the association to produce it or retract all fines. I send the letter by certified mail to the management company and to Teresa's listed address on the resident directory. I keep the tracking receipts. Paul says the next step is to wait and see if they respond, and if they ignore it or retaliate, I should file a complaint with the State Attorney General's office. If you are enjoying this story, hit like and subscribe for more HOA chaos and satisfying payback. 2 days later, I get a response, but not the one I expected. Teresa shows up at my door at 8 at night with 2 other committee members I have never met. One is a man in his 50s holding a tablet. The other is a woman in her 40s with a camera on a strap. Teresa says they are conducting an emergency inspection under the association's winter safety protocol, and I am required to provide access to my driveway and side yard. I ask to see the authorization. She holds up a printed page with the Timberline Whiteout Ridge logo and says the board voted last night to authorize spot inspections for any property under dispute. I ask when the vote happened. She says it is in the minutes and I can review them on the portal. I tell her I do not have portal access because the association suspended it. She says that is my problem, and if I refuse entry, they will escalate to a formal hearing with penalties. The man with the tablet says they just need 5 minutes, and they will be out of my way. I step outside and close the door behind me. I tell them they can inspect from the driveway, but they are not entering my yard without a written notice delivered 24 hours in advance, which is the covenant requirement for property entry. Teresa says the winter protocol overrides that. I ask her to show me the protocol document. She does not. Instead, she walks past me toward the side gate. I step in front of her and say she does not have permission. She pulls out her phone and starts recording. She says I am obstructing an official inspection, and she is documenting my refusal for the board. The woman with the camera takes photos of me standing in front of the gate. The man with the tablet taps something and says they have enough for a report. They leave. The next morning, I get a notice by email. It says I refused a mandatory safety inspection, and the association is imposing a $500 obstruction fine plus a mandatory hearing in 10 days. I forward it to Paul and Marcus. Paul calls me 30 minutes later and says this is retaliation and I need to document it immediately. He says the emergency protocol Teresa cited does not exist in the covenants and the spot inspection rule is fabricated. He says I should file a police report for trespassing and harassment. Even if the police do not do anything, it creates an official record. I call the non-emergency line and explain the situation. The dispatcher says an officer will come by later today to take a statement. Marcus texts and says he saw the inspection attempt from his window and he will be a witness if I need one. The officer shows up at 4 in the afternoon. He is young and polite, and he takes notes while I walk him through the timeline. I show him the demand letter, the doorbell footage, the violation notices, and the email about the obstruction fine. He asks if Teresa has made physical contact or threatened violence. I say no, but she has trespassed and attempted to enter my property without permission. He says that is technically a civil issue unless I want to pursue a restraining order, but he will file an incident report for harassment and I can reference it in any legal action. I ask for the incident number. He gives it to me and says I should keep all my documentation and consider talking to a lawyer if the HOA keeps escalating. I thank him, and he leaves. I add the incident report number to my binder. That night, Marcus texts me a screenshot from the neighborhood group chat. Someone posted about a special meeting scheduled for next week to discuss snow compliance enforcement. The message says the board is proposing a new emergency rule that allows immediate fines for any snow-related hazard without prior notice. Marcus says this is Teresa trying to lock in her fake rules before anyone can challenge them. I check the portal, still no access. I call the management company and Brenda answers. I ask if I am being notified about the special meeting. She says notices go out by mail 3 days in advance. I ask if I can attend even though my portal access is suspended. She says yes, any resident can attend. I tell her I will be there. She says she will note it. The meeting is scheduled for Thursday at 7. I spend the next 3 days preparing. I print copies of every document in my binder, plus the incident report summary and the demand letter. I also pull up the original covenant language and highlight every section that contradicts Teresa's claims. Paul agrees to come with me as a witness. Marcus says he will be there too. The night before the meeting, I get a certified letter. It is from the management company, and it says my dispute packet was reviewed and denied because I failed to provide sufficient evidence of rule misapplication. The letter says the association is moving forward with collection, and I have 10 days to pay the outstanding balance of $825 or face a lien filing. I read it twice. There is no explanation of what evidence was insufficient or who reviewed it. I scan the letter and add it to my folder. Paul says this is exactly what happened to him. The management company manufactures a denial to justify the fines, then uses the unpaid balance as leverage. He says the meeting is my chance to flip the script. Thursday morning, I wake up to 6 inches of new snow. The plow comes through at 5 and dumps another wall across my driveway. I shovel it before work and pile the snow in the side yard, well away from the curb. I take photos with timestamps. At noon, I get a text from Teresa. It says the association is conducting a pre-meeting inspection of all properties under dispute, and I am required to be present. I do not reply. At 2, I get a voicemail from Brenda saying Teresa reported that I am non-compliant with snow removal and she is recommending an additional fine. I save the voicemail. At 5, I leave work early and drive home. Teresa's car is parked in front of my house. She is standing in my driveway with the bucket of gravel and a man in a contractor vest holding a clipboard. I park on the street and walk over. Teresa says this is the association's compliance contractor and he is documenting the drainage damage I caused. I look at the contractor. He does not make eye contact. I ask Teresa if she has a warrant or an easement agreement. She says the association has access rights under the emergency protocol. I tell her there is no emergency protocol and she is trespassing. She says if I obstruct the inspection again, she will have my car towed. I pull out my phone and call the police. I tell the dispatcher I have trespassers on my property refusing to leave. Teresa hears me and her face goes red. She says I am harassing her and she is documenting this for the board. The contractor says he is just doing his job and he does not want trouble. I stay on the line with dispatch. Teresa and the contractor get in their cars and leave before the officer arrives. The officer is the same one from before. He takes another statement and updates the incident report. He says if they come back I should call immediately and he will issue a trespass warning. I thank him and he leaves. I check my watch. The meeting starts in 90 minutes. I arrive at the community center at 6:45. The meeting room is set up with a long table at the front and rows of folding chairs. About 20 residents are already seated. Paul and Marcus are in the 3rd row and they wave me over. Teresa is at the front table with 4 other board members and Brenda from the management company. Teresa sees me and her expression hardens. She leans over and whispers to the woman next to her. I sit down and set my folder on my lap. At 7, the board president, a man in his 60s named Donald, calls the meeting to order. He reads the agenda. The first item is a motion to adopt an emergency snow compliance rule allowing immediate enforcement without prior notice. Donald asks Teresa to present. She stands and walks to a podium with a microphone. She says the association has a responsibility to protect property values and resident safety, and the current snow removal process is too slow to address hazards. She says the new rule will allow committee members to issue fines on the spot for any violation, with a 48-hour appeal window. She says this is necessary because some residents are refusing to comply and creating liability for the association. She does not name me, but everyone in the room knows who she is talking about. Donald asks if there are any questions. I raise my hand. He nods. I stand and say I have questions about the legal basis for the emergency rule and the evidence the committee is using to justify it. Teresa says the floor is for board questions only and I will have a chance to speak during public comment. Donald says that is correct and asks me to sit. I sit. Paul leans over and whispers that I should wait for public comment and then unload everything. The board votes. The motion passes 4-1. Donald announces that public comment is next and residents have 3 minutes each. I am the first to stand. I walk to the microphone and set my folder on the podium. I introduce myself and say I am here to dispute 3 violation notices issued by Teresa Stewart that are based on rules that do not exist in the covenants. I open the folder and hold up the original covenant pages. I read the snow removal section out loud. It says nothing about curb setbacks or drainage liability. I show the portal screenshots proving there is no winter addendum. I describe the doorbell footage showing Teresa documenting a violation after I corrected it. Teresa interrupts and says I am misrepresenting the facts and the committee has photographic evidence of my non-compliance. I ignore her and keep talking. I describe the gravel bucket and the trespassing incidents and the false inspection attempts. I hold up the incident report number and say I filed a police report for harassment. I said the management company lost my dispute packet twice and denied it without explanation, and I am requesting a full refund of all fines and fees plus a formal apology. Teresa stands and says I am lying and the committee followed procedure exactly. She says I refused mandatory inspections and obstructed compliance work, and the association has every right to enforce the rules. I pull out the demand letter and hold it up. I say I sent this by certified mail 10 days ago and the association has not responded. I read the deadline paragraph out loud. Teresa says she never received it. I pull out the tracking receipt showing delivery to her address. The room goes quiet. Donald asks Brenda if the management company received a demand letter. Brenda flips through a binder and says she does not see it in the file. Paul stands and says he sent a similar letter last year and the management company lost it twice before refunding his fines. He says this is a pattern and the board needs to investigate. Another resident stands and says Teresa fined her last month for ice on her mailbox post and she never got a hearing. A man in the back says the same thing happened to him. Donald bangs the gavel and asks everyone to sit. He says the board will take this under advisement and schedule a follow-up. Teresa says the residents are coordinating a smear campaign and the board should not be intimidated. I watch her pile on threats, because that is exactly what I needed her to do. I reach into my folder and pull out the final piece. It is a chain of certified letters proving the HOA received my cure and fined me anyway. I sent photos of the relocated snow pile the morning after the first notice. The tracking shows delivery. The second notice was issued after delivery. Teresa violated her own process. I walk up to the front table and hand the officer on scene the proof and ask for an incident number immediately. The officer looks at the tracking receipts and the doorbell stills. He nods and writes something in his notepad. He says he will include this in the updated report. Teresa's face is white. She says the tracking does not prove anything because the photos could be fake. I pull out my phone and play the doorbell video on the screen. The timestamp is visible. The snow pile is gone. Teresa is taping the notice to the door. The room watches. Someone in the back says this is insane. Teresa grabs the microphone and says the rules do not care about your excuses and neither do I. The woman next to Paul stands and says that is exactly what Teresa told her when she disputed a roof fine, and she is tired of the committee making up rules. Another resident says the same. Donald tries to regain control, but the room is loud now. Brenda stands and says the management company is conducting an audit of all enforcement actions from the last 6 months, and the board will receive a report next week. Teresa says that is unnecessary, and the committee has acted in good faith. Donald says the motion to audit is already approved and the meeting is adjourned. People crowd around me after the meeting. They want copies of my documents. Paul helps me hand out the covenant pages and the demand letter template. Marcus says 3 more people told him they were fined by Teresa this winter and they never got hearings. I tell them to file written disputes with Brenda and reference my case. Teresa leaves through the side door without talking to anyone. I pack my folder and walk out to my car. The air is cold and the streetlights are reflecting off wet ice. I sit in the driver's seat and exhale. My phone buzzes. It is a text from Brenda. She says the audit uncovered discrepancies in Teresa's enforcement records and the board is scheduling an emergency session tomorrow night. She says I should attend. The emergency session is Friday at 7. I show up early. The room is packed. Paul and Marcus are there. So are at least a dozen other residents I recognize from the meeting. Teresa is not at the front table. Donald opens the session and says the management company completed a preliminary audit and found multiple enforcement actions that violated the covenants. He says the board is voting tonight on corrective measures. Brenda stands and reads from a printed report. She says Teresa issued 43 violation notices this winter. 21 were for rules that do not exist in the covenants. 18 were issued after the resident had already cured the violation. 4 were based on fabricated evidence. The room erupts. Someone yells for Teresa to be removed. Someone else says they want refunds. Donald bangs the gavel. Brenda says the board is recommending full refunds for all affected residents and immediate suspension of Teresa Stewart from the landscaping committee. She also says the board is recommending the management company lose its contract for failing to catch the violations. Donald calls for a vote. It passes unanimously. Teresa walks in during the vote. She is holding her phone, and her face is red. She says the board does not have authority to suspend her without a hearing, and she is filing a lawsuit. Donald says she can file whatever she wants, but the vote stands. Teresa says, "You should have read the rules before you moved in, sweetheart," and looks directly at me. The woman next to Paul stands and says Teresa said the exact same thing to her last year when she disputed a fine, and it is clear Teresa does not follow her own rules. Another resident says the same. Teresa yells that the residents are lying and the board is corrupt. Donald says she is out of order and asks her to leave. She refuses. He calls a recess and asks Brenda to contact building security. Teresa storms out before security arrives. The board reconvenes. Donald says the association will issue refunds within 30 days and appoint an interim landscaping lead. He also says the board is commissioning an independent review of all HOA policies to ensure compliance with state law. He opens the floor for comments. I stand and say I appreciate the audit and the refunds, but I want confirmation that Teresa will not have access to enforcement tools going forward. Donald says Teresa is suspended from all committee roles effective immediately, and the board is reviewing whether to pursue removal from the association entirely. I sit. Paul stands and says the association should also compensate residents for time and legal costs incurred due to the false enforcement. Donald says the board will consider it. The meeting ends at 9:30. Over the next 2 weeks, the fallout accelerates. Brenda calls me and says my refund check is ready. It is for $825 plus $150 in processing fees. I pick it up from the management office. The next day, Teresa resigns from the board in an email that gets forwarded to the entire neighborhood. She says the residents are ungrateful and the association is going to collapse without proper leadership. No one replies. 3 other board members resign the following week. Donald stays on and organizes a special election. 5 new board members are elected in March, all of them residents who were fined by Teresa. The new board votes to terminate the management company contract and hire a firm that specializes in covenant compliance. They also vote to eliminate all emergency enforcement rules and require 24-hour notice for any inspection. In April, the association holds a town hall to review the new policies. The room is calm. The new board president, a retired teacher named Linda, walks through the updated snow removal guidelines. They are simple, and they match the original covenant language. No curb setbacks. No gravel evidence. No spot fines. Violations require written notice and a 72-hour cure window. Disputes go to an independent arbiter, not the committee. Linda says the board is committed to transparency and resident input. She also says the association refunded a total of $12,000 to 19 households affected by Teresa's enforcement. The room applauds. I sit in the back with Paul and Marcus. Paul leans over and says this is what it looks like when the process works. Marcus says it only worked because I fought back. I get home and check the mail. There is one envelope from the HOA. It is a formal apology letter signed by Linda and the new board. It says the association regrets the enforcement actions taken during the winter and acknowledges that the violations were improperly issued. It also says the board has implemented new training for all committee members and management staff to prevent future issues. I fold the letter and put it in the binder with the rest of the documentation. The binder is thick now. I set it on the shelf in my office. I do not think I will need it again, but I keep it anyway, just in case. Outside the window, the snow is melting. The curb is clear. The driveway is dry. The neighborhood is quiet. A few weeks later, I run into Teresa at the grocery store. She is alone, and she does not look at me. I do not say anything. I finish my shopping and leave. Marcus texts me later and says Teresa moved out of the neighborhood. He heard she bought a condo in Moorhead. I reply that I hope her new place does not have an HOA. He sends a laughing emoji. I close the thread and put my phone away. That night, I sit on my front step with a cup of coffee. The air is cool and the streetlights are on. A neighbor waves from across the street. I wave back. The bucket of gravel is gone. The violation notices are gone. The fear of coming home to a tow truck or a lien notice is gone. I take a sip of coffee and watch the sky turn dark. It feels like I can breathe again. Thanks for watching, and I appreciate you being here.